about that in my
Yeah.
business stuff side of my business. I mean, there's no reason why I have to worry about a disclaimer there, because no one's going to somehow do something and then try to sue me because they followed my advice there. Now, I think, and I'll be honest with you, I think the chances that people are going to sue you for following your advice are pretty stinking low no matter what.
Yeah.
But there's more risk if you're, a coach than if you're,
Yeah.
just providing like things like marketing strategy and those types of things.
Yeah. My special guest, a very welcome. Thank you for joining us today, Bobby.
Thanks for having me, Arfan. I'm excited for this session as much as we can really be excited about a conversation about legal stuff. But, I think we'll make it light, enjoyable, and not too boring. That's always my goal with these kinds of shows.
Yeah, and that's one thing I like about you, Bobby, is that as long as I've known you, you've never gone too much with the legal talk or the legal jargon to the point where it's like, man, my eyes start glazing over, my ears start just thinking about other things. So I'm excited to actually dive into this, because at the very end of it, I can guarantee you that for some reason you're going to be like, wow, I want to actually do this. And I think it's like a superpower, Bobby, where it's like, why do I all of a sudden feel like I want to get legally protected? So we're going to definitely go into these policies here. So if you're meeting me for the very first time, I'm Arfan. My team and I help coaches leverage paid advertising through Facebook and Google so you can grow your audience, automate the lead generation, and scale their paid offers. So Bobby, I'm gonna have Bobby introduce himself, but I did kind of mention that Bobby is he makes legal kind of fun, which is even saying those words kind of come a little bit weird, but it's true, and you're gonna see it. But since we're talking about the legal side of business, I refer to Bobby as the expert in my space, anyways, when it comes to legally protecting your coaching business, your online coaching business, if you want to be really specific. So, Bobby, why don't you go ahead and give us an introduction? Tell us a little about yourself and who you are, and why you do what you do, sir.
Yeah, so I'm Bobby Klinck, professionally sometimes known as Robert Klinck, but the only people who ever call me that are my mom when she's mad at me, my wife when she's mad at me, and back when I practiced law, the judges. But I'm a Harvard Law grad, and for the first 10 years of my legal career, I had the type of career that really every lawyer would have dreams about. After graduating with honors, I clerked for a federal court of appeals judge for a year, then worked at some really prestigious firms here in Washington, D.C., where I'm located, including one where my mentor, the guy who recruited me to the firm, was a guy that I just knew as Neil. Now we have to call him Supreme Court Justice Neil Gorsuch. So, I mean, that was kind of the circle that I lived in. And then I was a federal prosecutor for a period. In 2010, I got the entrepreneurial bug. I guess I always had it, but I finally really kind of took that path and joined a small entrepreneurial firm. But I made one of the big mistakes that a lot of entrepreneurs make, which is they get very excited and they just jump into things without getting an agreement in place. So this was a small law firm. It was these two guys. It was largely plaintiffs' contingency fee work, big, huge cases. But they didn't have a lot of cash in the bank. And so I agreed to come on, and I was a partner in name, but I wasn't actually a partner in the firm. And the problem was I had all the downside risk. So when the firm didn't have any money coming in, I wasn't getting a paycheck. Now we would get a settlement and then I would get paid, right? And I would normally get these big chunks of payments. The problem was I had no guaranteed upside. So if the firm went belly up, I had all the downside, but none of the upside, because if we'd hit like a $10 million judgment or $10 million that the firm brought in, I wasn't guaranteed any piece of that. And so they'd always treated me fairly while I was there, but my wife got pregnant and I said, we should get this in writing. We should figure out, I want to actually be an equity partner in the firm. We need to talk about what that looks like. And as often happens, trying to negotiate that after the fact did not work well. It didn't end well, because at that point, all of a sudden you're in what I guess economists or people would call a zero-sum game. Like every point of equity they give me is taking away real money from them. And they really saw that. And so we were unable to come to an agreement. And it was one of those things that it led to some hurt feelings. So that was in the end of February of 2014. One of those guys had flown through Hurricane Sandy to the Bahamas in a like 10-person little plane to get to my wedding. I haven't talked to him since February of 2014. So it kind of ruined our relationship, in addition to me then basically saying, okay, while I'm holding my 3-month-old baby, I on a Sunday night, it was snowing. I remember I looked over at my wife, and my brother-in-law was here at the time. I said, we got to go to the office. And I literally took all of the stuff that belonged to the firm that I had. And it wasn't that I was fired, but I just knew it was over. And so I went and hung my own shingle in March of 2014. And I was a practicing lawyer, and I was doing these things. The problem was I kept seeing, I did IP law, so I did patent litigation and things like that. But I would also see entrepreneurs come to me when disputes came up. And the tale was always the same. They had gone without dealing with the legal stuff early on because it was too expensive. And I get that. I mean, I was billing at the time, I think I was charging myself out at, I don't know, $375 an hour or something. And so that meant that, like, just to hire me to write a basic contract, you'd be talking about $4,000 probably or more. And so that's where I was. And then in 2017, I was working with a life coach that I'd started working with in 2016. And she finally asked me the question of whether I liked what I did for a living. And I admitted I didn't. I didn't like practicing law. I like law. I like legal questions. I like all of that stuff. But the actual practice, which had me fighting with other lawyers and just doing a lot of that stuff, was not for me. And so that started a quest for me of building an online business. And so I've since built an online business where I sell legal templates that make it very simple. And that the point is to get over the issue of you can't afford it. That was my goal. And so I've set that as a quest to make legal stuff affordable to people at every phase of business.
That's awesome. Well, I'm glad. I mean, going through it doesn't always feel good, but I'm happy you went through all that, because we're here now, and you've accomplished, in a sense, what you set out to do. So I'm thrilled. And if you're, when you're listening to this, what I said, Bobby doesn't make this boring, right? I enjoyed his story. Like, I was in there, I was visualizing it. I'm so flying through Hurricane Sandy. I'm in Florida, and I've gone through my fair share of hurricanes. I've seen some trees fall down, power outage for a few weeks. For someone to fly through a hurricane, hit your wedding, and then so we're talking about a serious situation here. So let's actually flip this around now. We're here now. You've gone through all of that. You set out for your mission, and you realized that what you were doing wasn't for you. You want to do something else. So you you took your hat, you hung it up in the online world now, and you set to make these things affordable to be able to get policies in place without having to spend $4,000 a policy on there. So today we're talking about the top 5 policies. So what would you say are the top 5 policies that you recommend business owners have when running their business online?
Well, so the first one, and again, this is the thing I tell people. I always like to be absolutely transparent with people that most of what I talk about, most of the things I'm recommending to you, most of the things I'm telling you about are not legally required. I know as a lawyer, you should have them, or you could run into the problems I had, a client who doesn't pay or something like that. But there is one policy that is actually legally required, and that's your privacy policy. So that's where everybody should start, because if you're collecting any personal information from anyone online, and hint, if you're building an online business, you are. Just assume you are. I don't need to go into why, but you're required to give some disclosures. And there's a couple of laws. There's laws in California, and a lot of people got all worried about this. I think it was in 2020 when a new law came out. That new law doesn't apply to hardly any of us, unless you're making $25 million or collecting information from 50,000 California residents a year. You're good. You don't have to worry about that one. But there's an older law that's been on the books since 2003, which is actually pretty amazing when you think about the internet, that California was that far ahead of saying, hey, if you're going to collect information, you have to tell people some things. Yeah. Then there was a European law that a lot of people heard about, GDPR, back in 2018. And it was funny when you were talking about, me not making this stuff boring. That really was where I started. Now, I had templates, but I got into teaching about the law around GDPR because I had a lot of people asking me, and I didn't want to create a training about it. I wasn't excited about that, but I had a lot of entrepreneurs asking me because I was in the space already. And I went and tried to watch these other trainings by lawyers, and it put me to sleep, and it confused me as a lawyer. It was like, if I can't understand this, how is a regular entrepreneur who's not trained in legal stuff at all going to understand it? And so that's been on the books for 4 years now. And so that one's been in place. And then there's other laws in different places. Australia has a law. There's a law in Canada. I think there's some South American countries that now have laws. So the point is that this is becoming a thing where you have to have a privacy policy. And it doesn't matter if you're in one of those places. What matters is if someone is visiting your website from any of those places and you're collecting their information, you have to have a privacy policy. So that's the first one. And this is where I'm very, go ahead, Arfan.
No, that's a big one, because I want to point out too, like when it comes to advertising to Facebook or even Google, one of the things they check is, do you have a privacy policy? And you need to have that. If you're doing on Facebook lead generation, you got to put your link to your privacy policy. It's a required field. So that's a great one.
Back in the day, I feel like they would more likely reject you, even if you were doing like sending someone to a landing page if the landing page didn't have a link. I feel like they're not doing that as much anymore, but I think you're supposed to have one on all those pages by their terms of service. But yeah, that's a big one. But this is another place, though, on the privacy policy where I'm different than most people, because a lot of other online lawyers, I think, figured out, hey, that's the one they've got to have. And so most people charge $200 and $300 for that template, even though it is one of the simplest templates if you're creating a template. Now, again, if you're doing it very custom, if I was creating a custom thing with you, Arfan, we would go into a lot of detail and we would be more specific in that policy than a template would, just for like belt, suspenders, and everything else. Why not? But just so you understand, I use my own templates for my own policy. So, I'm not doing anything else. But a lot of people charge $200 and $300, and I decided back in 2019 to just give that policy away for free. And I view it as hey, I don't think you ought to have to pay money to follow the law. And so we made that decision and made it free. And to this point, I've moved systems, so I don't have an exact count, but we've given it. We've had over 20,000 entrepreneurs download that one policy. And it makes me happy to think about the fact that I've given that much away. And I think we're probably at this point approaching 25 to 30,000. So that's the first one. And that's kind of
we'll tack some more on there. I'm going to put a link somewhere here so you guys can, if you listen to this, you don't have a privacy policy, we'll get a link so you can grab that for free.
Yeah. And just so you know, like what we did, by the way, especially we started with privacy policy, but now all our templates, except for one, have a generator. So you don't even have to customize it yourself. You answer questions and it customizes it for you. So we wanted to, you say I make the legal stuff fun, and maybe in these discussions I can make it fun. I don't think I can make the creation of a legal policy fun, but what I can do is make it completely painless. And so that's been our goal. And so, if you grab that link to the privacy policy that Arfan has here, you'll be able to go and you can try it out. You can see what the generators look like, and you'll get it for free. And my commitment to you is, in 5 minutes, you could have a complete privacy policy that you're then ready to put up on your website.
That's awesome.
So that's the first policy. I'll talk about two other policies kind of together now, because I think of these as the other two policies for your website. These are not about you being a coach or about your product. They're just about your website. You're going to have sometimes it's a terms of service or terms and conditions. There's a lot of different terms for it, but think of it as your terms of use, I think is the term we tend to use, and a disclaimer. And sometimes some people will put those together. I put them separate because they serve slightly different roles. The terms of use is basically, the way I try to describe it to people is, this is the basic rules of the road for your website. And it's setting out kind of background rules. So if someone doesn't sign another agreement during a process and they're using your website, they're downloading stuff, or maybe they're buying some little $7 product, those rules will apply, whatever's in the terms of use. And you'll get people to click a box to accept those terms during a checkout process. But these are pretty simple. There's some stuff in there which is, boring legalese, like no one wants to read it. And people always ask me, why do we have those big, ugly legal phrases? And do I need that? Can I just not include that? Can we put it in regular English? And what I like to tell you is, you could, but let me explain how that those big, ugly sentences that are like 8 lines long in a legal document, let me explain how those came about. And I do this because I hope this will make people understand I probably shouldn't touch those.
Yeah.
What happened was, it started as a very simple sentence. By the contract drafters, they drafted a very simple sentence. And then some ambitious lawyer who wanted to raise a dispute filed a lawsuit and found a loophole, and they won. So then contract drafters said, okay, well, we're going to close that loophole. And so they added a phrase or two to close that loophole. And then what happened is some other, entrepreneurial lawyer found a way to find another loophole. And so what's happened is progressively over time, those sentences have gotten more complicated in a lot of this stuff, like a limitation of liability and this stuff that you'll have in a lot of these documents, because contract drafters have continued to close loopholes over time. And so if you ditch all that stuff and go very simple, you might not actually be protecting yourself. And so that's why I tell people, look, I don't like reading the legalese. I hate it. I don't like writing it, but it's there for a reason. And so for the most part on that stuff, just kind of just leave it. You don't mess with it. And when with all my templates, I have a section, I have a video where I explain what it means. And so you can explain that to a client or whatever if they have a question. But I do want to say, don't do that. So your terms of use has a lot of that at the end. It'll have things like a limitation of liability. It'll have things that say you can't sue me because it'll have sections about what happens if there's a dispute. It has a lot of that stuff, but it also has things like your background refund policy. Do you give refunds? Yes or no? Under what conditions? Those are the kinds of things that you want to make sure are covered in your website terms of use. So we use those for a lot of our legal templates. I don't think we have separate agreements. I would have to ask my team, but I don't think we have a separate agreement or terms that people use. It's just that background policy. And among other things, it says that for our individual templates, people can have one refund, but they can't have a second one because we don't want people downloading. I mean, once they've downloaded one, they know what it is. I mean, they know what they're getting. And so, it's a digital product. So obviously people could theoretically do it. So we say, hey, you can have one refund, but not more than one on legal templates. So it's things like that you can spell out in your terms of use that define the overall rules of the road. Now,
I'm glad you're bringing this up, because this is things that, we're creating a product as a coach, like, hey, we're supposed to sell offers, make offers out there, but we're not thinking about this. Like, hey, someone's going to download and refund and request another refund or things like that. So it's this is important. This is good stuff.
Well, and what I want to say is, like, when you have an actual package where people are going to pay you a significant amount of money, you're going to have a separate agreement. And we'll talk about that in a second. But having this basic thing in place that lays out the background, the background policy, I think is important, because that way, if nothing else, you've got that. So if nothing else, you have this kind of general policy in place. And so that's where your website terms and conditions can come in. Now, the disclaimer is, I like to say, this is the document that there's a couple things it does. Number one, it's you can't sue me because. It has a whole list of reasons they can't sue you. So yeah, we should all like that. We should all say, hey, this is good. We want to say you can't sue me because. But the other really important part of the disclaimer is to tell people that your website is not providing any kind of professional advice. So in my case, mine will say that I'm not providing legal advice because I have legal templates, but it will also say that I'm not providing marketing or other professional advice. And the reason for that, and people say, but I am. I say, no, you're providing education and information. The way I look at it, and from a legal perspective, I think the way we should all look at it is, I can't provide advice without talking to you, without knowing information about you. That's when it's advice, when I'm actually customizing it and tailoring it to you from a really legal perspective. So you're just saying things like that, and then saying, so you're taking full responsibility for deciding what to do with the information I provide, and decide whether you're going to follow this or not. And if you're a coach who does anything that's health related, it's especially important to say that this is not a substitute for medical advice. This, don't take this as medical advice. And you might even add something in there that says, and consult with a doctor before you start a health and fitness regime, just because you want to cover yourself so that someone doesn't get mad. So that, broadly speaking, is what your disclaimer is. There's some little other things in there that we put other stuff in there that doesn't even cover us anyway, like that we have affiliate links. But you can't just say I have an affiliate link and just put it in your disclaimer. You actually have to disclose that affiliate links are affiliate links near where they appear. So we put that stuff in there, but you're still going to have to do more work as you're doing those things more generally to protect yourself. So that's the disclaimer. So now let me kind of do a quick recap, because we've covered 3 policies and all of them are basic website policies: your privacy policy, your terms of use, and your disclaimer. So those are the kind of the triad, or the 3 different things that you'll have on your website. And people ask me, well, where do I put them? You create a separate page on your website for each one of them. That's not in your main navigation bar, but you'll have links in the footer of your website that links to each of those pages. And then if you have an opt-in page or anything like that, and then like you said, for your privacy policy, you'll have that on any lead forms you create on Facebook and those types of things. You'll need to put it there as well. So that's your website. Do we cover that well? Anything else we should talk about the website?
No, that's great. I mean, I like those. That covers quite a bit. I'm glad you also went a little in depth in it. So it's not just like, hey, these are the 3 policies, blah, 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 but actually the reasons why, because we can see now as a coach, someone who's operating online, where the gray areas can easily come up, especially if we're not thinking about it. Like, hey, I'm just excited about putting an offer out there, excited about promoting something, and we just miss this little step. It could be something so quick, so simple, just to add that button to the footer. Footers on every page added to added disclaimer. So thank you for going into those 2 as well.
And then, like, people will also ask me, for example, so if you create these, and let's say you're a coach who has a YouTube channel, right? You might as well add links to at least your disclaimer in the end of kind of the notes on your YouTube, kind of on the descriptions. You'll know what those are called better than me, Arfan. But the reason for that is simply, a lot of people ask me that. Well, do I need to? Now, you probably don't need to, but why not? So that way you don't have to feel the need, because people will say, do I have to say at the beginning of every video that this is for educational and informational purposes only?
Yeah.
I would say no, but if you're worried about it, you can just link to the disclaimer in your captions or whatever they're called. I forget what they're called. The descriptions, basically. Your written descriptions. And that way you have that there and you have that protection as well. And this is especially important for coaches. I mean, it's not as big a deal for me if I'm going on there and talking about marketing at this point. Because if I'm talking about, hey, should you pick ConvertKit or MailChimp, for example? I just did a video about that in my business stuff side of my business. I mean, there's no reason why I have to worry about a disclaimer there, because no one's going to somehow do something and then try to sue me because they followed my advice there. Now, I think, and I'll be honest with you, I think the chances that people are going to sue you for following your advice are pretty stinking low no matter what.
Yeah.
But there's more risk if you're, a coach than if you're, just providing like things like marketing strategy and those types of things.
Yeah. So a health coach is doing a YouTube video and says, let's say, like the top five foods for weight loss. But definitely want to make sure you have a disclaimer on there that this is not actual health advice, and to consult the physician for actual weight loss.
Exactly. I mean, and it's one of the things you just might as well do it, and you can think about it. So, but that's kind of those broad disclaimers. Now, the next thing I want to talk about is your coaching agreement. And so one of the things I tell people is, especially in an agreement like this, where it's a service, right? Where you're going to be doing something and they're going to be giving you something else. You should not exchange money until they have agreed to an agreement. Now, it doesn't have to be in the process. You could have them pay you and then send you the agreement and then you get it back, but it should happen basically contemporaneously, right at the same time that the payment is happening. You want them to agree to your coaching agreement. Now, your coaching agreement, it's going to have some of that same disclaimer language. It's going to put in there that, this is not, a substitute, especially if it's medical, that it's not a substitute for, if you're a health coach, that it's not a substitute for medical advice. Like, you're going to put those kinds of things in your coaching agreement. But the big thing about the coaching agreement is it's going to set out the essential features of the agreement. How much are they paying you? When are they paying you? And what are they getting in exchange? And you want to be clear here. And what I like to tell people is, lawyers love gray area. So if you want to avoid spending a bunch of time with lawyers who, by the way, most of them aren't nearly as warm and fuzzy as me, the best way to do that is have written agreements that are very clear and specific about these kinds of things, about the core issues in an agreement, because then there's just no room for agreement. Now, again, I want to be clear. The chances that you're going to find yourself in a legal dispute aren't great as long as you're doing your job and you set your thing up right where you don't get out ahead of the payments, right? I mean, there's a lot of things you can do to protect yourself, but having this policy in place is important. Especially, for the one-on-one coaching, your coaching agreement does this, and that's all about it. But some of the stuff that you might not think about, but that you need in there is, if you're doing one-on-one calls, you have to set a cancellation policy. Like, how far in advance do they need to cancel to not use that as one of their calls? Because you've booked that time, you've set that time aside from them. And so you could say 24, you could say 48, you could say 72. I like to tell people, be reasonable. And also, even if you said 72 hours, that they have to cancel 72 hours in advance, or it will, count as having been used. If one of your clients reaches out 24 hours in advance, and I mean, they have a really legitimate reason, not an excuse, but a legitimate reason that they need to cancel, guess what? You can still say, I'll let you cancel this time and we won't count this against you. Even though under the contract, you would have a right to count it against them. Yeah. Having a contract doesn't mean you have to enforce it. You can always show grace, but having the agreement that lays this out is what gives you the option of figuring out what to do that. If you didn't have, let's say if you didn't have anything about a cancellation policy in the agreement, theoretically, they could cancel 5 minutes before and they would say, well, I didn't use my call. What are you talking about? I'm entitled to another call. And what is the answer? I don't know. I mean, there's not a clear answer about who would win in that situation, but you wouldn't clearly win. And so you want to set it up so there's just clear expectations. But again, I want to say this isn't just about legal protection. So earlier when I talked about the legalese being written in a very specific way, that's written that way for a purpose. But these core parts about what they get and cancellation policy and stuff like that, that should be written as plain English for them to understand. And the big part, the big value of this is setting expectations up front so that your relationship will be smooth. So it avoids disputes in the first place. And I like to tell people, separate from that, we humans tend to think that our memories are way better than they actually are. The reality is that a lot of what we remember is constructed based upon talking about it or something else, not actual memories of the time. And also our memories over time, they tend to fade and drift more and more in our favor. So I use this example so that if people had a handshake agreement as a contract, right up front, they might be in complete agreement. But 6 months down the line, you know what's going to happen? They're not going to be in an agreement anymore. And they're both sides are honestly going to believe what they're saying. This isn't going to be one side trying to be a jerk and trying to do. They're honestly going to believe that what they're saying is right. And an example, it's not a coaching example, but let's say it was a copywriting agreement. The copywriter might agree that said, hey, there was going to be no revisions. Whereas the client would say, no, I had unlimited revisions. And both sides will honestly believe that. If you have a written agreement, you address those things. And so then 6 months down the line, what do? If this comes up, you go back and look at the agreement. And you might be right, you might be wrong, but either way, neither side is going to feel like they're getting, mistreated. The side that's wrong will be like, oh, you're right, I was wrong. Okay, cool. And that resolves the issue. So that's kind of what your coaching agreement is meant to do, is to help create that kind of good relationship that works well over time.
Yeah, I like that one a lot because it does clearly say it out. And you don't got to be a stickler. What I hear you saying is you don't got to be a stickler to it. So if you do have a 24-hour notice, something like that, things can happen. Someone could be driving and get in an accident or something like that. And you can't, you'd like, oh, my contract says 24 hours. So you use the reaction, like you can still be human about it.
Right, exactly. And so again, this is where there's some of that legalese in contracts. So like in all my templates that have these things, there will be a clause that I forget whether it's titled waiver or no waiver or something like that. But essentially it says something like this, that either party can waive any part of this agreement one time without it meaning that they have to waive it in the future. So in other words, it's saying, hey, I can give you this excuse now and say, yes, I'll let you cancel now, but that doesn't give you the right in the future to do that. And that's the other stuff you just want to be thinking about so that it's handled the right way in your written agreements.
Gotcha. So I can't have an accident every Tuesday morning before my before
Right. I mean, and again, like I would say, like it's not like, again, you're going to be human about this. But it's like at some point you might say, hey, there's some scheduling issues happening. And again, like there's the accident. You talk about that, but I mean, it really depends on what kind of coach you are. But if you were a business coach, for example, let's say that someone 24 hours before they were supposed to have a call with you got an amazing opportunity to record a podcast with someone or be on a video show at the time you're supposed to have your call. Me as a business coach, I say, hey, do it. I want you to do that because that's going to help your business. But if that starts, like if that type of thing happens over and over again, you're like, something's wrong here. Mm-hmm. But those are the things that you just need to be reasonable and be a human being. You don't have to be overly legalistic about these things. So
yeah, I like that one a lot.
So I mean, the last thing, like the last agreement that I would talk about is it's kind of a category of agreements, and I'm going to call it program agreements. Broadly speaking, there's different kinds, but this is something separate from your coaching, your one-on-one coaching. As you build out any kind of scaled product, whether it's a course, a membership, a group coaching experience, a mastermind, anything like that, or if you start selling digital products that are an expensive digital product, you're going to want to have a separate purchase agreement for that particular product. And it will look very much like your coaching agreement, but it's not a one-to-one. And it won't be directly signed by people, even through like a DocuSign or something like that. It'll just be they check to accept it as they purchase the program. But there are some distinctions between the two. So a course agreement will generally have a refund or no refund policy. So you'll have to lay that out. And depending on what you choose, be specific. Like I know a lot of people have a show your work refund policy. And I say, okay, cool. If that's what you're going to say, you need to describe it in such detail here in the terms that when someone asks for a refund and shows their work, there will be no doubt. There will be no question. Either they will qualify or they will not. And that's how specific you need to be. So it's not like you do the work. You can't say that. You have to say, that whatever you want to require, you have to be very specific and say that they'll submit it or do whatever it is.
That's a very common one. I've seen those quite a bit for a lot of programs, courses, group programs, things like that.
Yeah. And like I said, I mean, I tend not to do that because personally, I don't want to have to review those things.
Yeah.
If someone asks for a refund. So when we have a refund policy, we just say, no questions asked, whatever. But if you want to do that, fine, but just be specific about it. But the other kind of agreement tends to be a membership agreement, which most times memberships are no refunds. So it's just gonna be no refunds, but you have to have a cancellation policy. How do they cancel? And what happens when they cancel? And some of this, like, I don't want to get too in the weeds, but part of this is you have to figure out, how does your technology system work? For example, I used to use a system called Cartro, and I don't know if they've changed this since, but when someone went, we could set it up so they could automatically cancel their membership. But if you had that set up, what would happen is the day they cancel, it cancels and removes their access from whatever program. Even if it was like on the first, like day 2 after they just paid for the next month, right? And so if that's the case, you need to be very clear about that. We didn't have that active for most of our things because we didn't want that. We didn't think that was right. So we would do the manual thing behind the scene, but just understand what the system is and be very clear. But this, by the way, is an exception. Earlier, I said very few things are required. And I said the privacy policy was the one. There is actually a law that requires, there's various laws that will require you to make clear how people can cancel, and don't make it hard. Don't make it impossible to find. So you do need that somewhere. It doesn't have to be in an agreement, but that's the easiest place to put it. So that's kind of your membership agreement. But in each one of these, you'll also explain what they get and basic things like that. And so those are, like I said, there's a class of different ones. I mean, we've created ones for courses, for memberships. I think we have a group coaching. I think we have a digital product one. So those are kind of different ones that you'll likely need at some point if you start to create a one-to-many scaled program.
Yeah. So as most coaches go through from first starting off, they'll do well just having a privacy policy, terms of use, and disclaimer, as they start working one-on-one and then start scaling into small digital products, 727, whatever the price point is, and even group programs at any value, the program agreements, this is where this comes in now.
Yep. Yep. And then again, we haven't even touched on this, but as you start to have other people working for you, whether it's contractors or employees, you'll need to have agreements with them. And those are like a whole nother, kind of whole other series of agreements, but you will need those over time as you grow. And with an independent contractor agreement, it's especially important. Now, hopefully they have an agreement for you, but if they don't, you need to have an agreement that you can send to them. And part of the thing is with those, I mean, there's some of it of just making sure that you agree on what the contractor's doing, what the price is and all that. But another piece is who owns the work product.
Yeah.
And you just need to define that, by the way, that the default should always be, once I pay you, I own the work product. And that's an important thing. And I had someone that I'll never forget. I'll never forget. I don't remember the person, but they had worked with someone who had created like yoga videos for them as a guest or something. And I don't remember exactly how it worked, but then that person was objecting at some point and said, no, I own those. You don't, you can't use them anymore. And they ended up in this dispute and there was no written agreement. And so, I mean, the person came to me and I said, well, I could spend a bunch of time and money and looking into this and figure out, well, what law applies here? Is it where you live, where they live? And then what is the law in that area and who wins, and dive into the facts. And I said, the problem is that's going to cost you, probably $10,000 at a minimum just for me to do the work. And there's no guarantees you're going to win. And so this is why you just need to have that stuff very clearly defined so that there's no dispute about these things.
Yeah, absolutely. It's just planning and preparing if it does happen. We're not expecting it to happen, but these policies are important. And that's so true, because I mean, especially working with contractors, things like that, I've seen where even with a policy, a contractor may even try to say, well, wait, you use the work as an example. Like, no, that's ours. It's not yours. You can't put that on your website. Sorry.
And what I'm going to go ahead and warn you, just so you're understanding now, photographers have the opposite presumption, just so that you understand. Photographers, because of history of the way that they built their business, the standard for photographers is actually that they continue to own it and they give you a license to the image. I don't like that. And I work with photographers who will go the other way and transfer it to me. But I just want you to understand that and again, we can have an interesting discussion about why that is, but it's largely because photographers, for a long time before we were using stuff digitally, they undercharged for the cost of actually taking the pictures and doing all that, because they were going to make their money by selling you the hard copies. And so because of that, they have to say, I own this, which means you can't even copy. You can't make a copy of what I sell you. You have to come back to me to buy it. And so because of that, photographers are different, but pretty much every other contractor I've worked with, the assumption is, once you pay me, you'll own the stuff. And you just need that spelled out though.
Gotcha. Well, I like that one. That's a little good program agreement. So that's gonna be important, especially like those who are listening right now. If you're a coach and you're thinking about, hey, I need to have these, planning out these different products and offers as you may be developing a funnel or just kind of mapping out how your business is going to go for the year. Just having the back of your mind, like, all right, let me get these policies too as well. So, all right, Bobby, thanks for sharing those different policies. So we covered 5, some were in groups, and I'm excited for these templates. It's one of those things at the beginning I said that at this point you might be excited to, like, you know what, I want to get my policies in place. I want to protect my business. And if you're like me and thinking the same thing, like, hey, I have some offers right now that I want to make sure my policies are in place. Bobby, can you share with us where we can get access to your templates?
Yep. So, I mean, I know you'll have a link that people can use, but basically we have a template shop that has, I don't know, I think it has 27, maybe 28. Don't quote me on the exact number. Total agreements. Now, there's a few that we don't sell individually. We throw in with different packs, but we sell individual templates. We sell the pack of the website policies. We have a coaching pack. So if you just want some agreements related to your coaching program, and then we have a template library, which is access to everything. And really most people end up going for that because it's the best deal. It's not nothing, but it's a steal of a deal compared to what you would pay otherwise. It's $14.97. So right around $1,500 or $147 a month if you want to make 12 monthly payments. And so it's not a membership. A lot of people think it's a membership and they're going to have to keep doing it. No, it's a product. You either pay me $14.97 right up front, or you pay me 12 payments of $147, and you get access forever. And by the way, this is actually something we didn't talk about in the product agreement, but so that you understand what forever, what lifetime access means, this is in our terms, so that you'd understand it. You define it as similar, that as long as we have this product up, you'll have access to it, and you'll have access to every template that's there now, and every template we add in the future, you'll get access to without having to pay anything additional. And if we're ever going to, like, if I was ever going to shut down my business or stop selling this product or something like that, we will let you know in advance, and we'll give you the opportunity to just download all of them. So you have it all downloaded, very simple, easy to use. So you're basically paying once to have access to the legal toolbox that will grow with you and your business over time. And what I like to think is that this is a product that really, yes, I'm selling you legal templates, but I'm also selling you legal peace of mind and financial peace of mind, that you're not going to have to be nickeled and dimed by me. I'm not going to, next time I release some new template, charge something else. Or I mean, there were people who charged for the privacy policy, and then when they updated it, they would make you pay again. And I was like, what? That makes no sense to me. If I decide that my privacy policy needs to be updated because there's been a law change, I'm going to update it. I'm going to tell you that it's been updated. You're going to be able to go back into our generator, generate it again, and you'll have a brand new policy. And so you get access forever. And like I said, it's less than it would cost you to have me draft a single agreement for you from scratch.
Wow, that's awesome. So I want to just kind of quickly process that really quick. So one time, $14.97. Access to 27 plus. It keeps growing. So Bobby's like, I don't even know how much I'm at right now. I just keep adding it. I think he just adds as he feels there's a need in the online business world. So that's awesome. And lifetime access. So this is just a one-time thing. So instead of hiring a lawyer for $3,000, $4,000, $5,000 for just one policy, you get access to 27 plus for lifetime. No updates, no nothing. And he's got a really cool generator, which even saves you time and energy and effort and mental sanity trying to figure out the legalese. So that's awesome. I'm gonna pop those links below so you guys can get access to that. It's definitely a no-brainer to get that legal peace of mind, as Bobby puts it. So again, Bobby, thank you so much for being here today. I'm gonna pop some links in the comments, the description below, and thank you all for joining us today in this video on the top 5 policies to have to legally protect your coaching business, especially when advertising. So I'm Arfan, and thank you so much.